Today's episode is about the Family Medical Leave Act of 1993. This act entitles you to take up to 12 work weeks of job-protected absences during a 12-month period for the birth of an employee's child and care of that child during the first year after birth, both mother and father, or for prenatal, if a mother's condition prevents her from performing the functions of her position. For the placement of a child for adoption or foster care or prior counseling sessions or court sessions, it expires 1 year after placement. Again, both for the father and the mother. For a serious health condition that makes the employee unable to perform the functions of their job within the meaning of the Americans with Disabilities Act, which would be an impairment that substantially limits a major life activity, even if it is episodic or in remission. And finally, to care for the employee's spouse, son, daughter, or parents, or adoptive and or foster parents, or those in loco parentis. And we'll discuss what this means. Now, you must have been employed for at least 1 year currently, as the law stands, in order to qualify, and you must also have 1,250 work hours going back 12 months from the first day that you use this FMLA protected leave. Now, what does in loco parentis means? In loco parentis means that this person is not your legal or biological parent. However, they raised you and stood in the parent's role for you. Now, if you apply with this provision, the USPS must inform you what documentation they need in order to establish this type of relationship and cannot summarily deny your application because of it. Now, all that is required is that the person either provided day-to-day care for you or provided you with financial support. They do not need to meet both requirements. A spouse is defined as a person to which you are married under any state's law or which could have been entered into under the laws of any state, including same-sex or common law marriage. A son or daughter is basically defined the same way as a parent. Or in loco parentis, as we've explained before what that means. Or a child over the age of 18 who has a disability under the Americans with Disability Act, which means they have an impairment which substantially limits a major life activity, or they qualify under the Rehabilitation Act, and the disability makes the person incapable of self-care. Now, what does that mean? Incapable of self-care is the need for assistance or supervision to provide daily care in 3 or more activities of daily living. For example, grooming, hygiene, bathing, eating, cooking, cleaning, paying bills, using a post office or phone, or shopping. Now, on return from an FMLA covered absence, an employee is entitled to return to the same position the employee held when the leave commenced, or to an equivalent position with equivalent benefits, pay, and other terms and conditions of employment. Now, our contract has additional protections up, over, and above what the law says, so you would never lose your position because you took leave for FMLA. Now, I know this goes more into defense of attendance discipline, but sometimes management will summarily or automatically deny an FMLA application because the person has fallen below the 1,250 work hours required. Well, according to the law, the employee only needs to qualify once at the time of the first usage of FMLA protected leave for that condition. This would mean that we would take the first date of usage and go back 12 months And if in those 12 months, the employee has the 1,250 hours, once they start using those weeks, of course, their hours may fall below 1,250, but that's okay. As long as they keep using it for that same condition, they will be entitled to 12 weeks of FMLA protected leave. Each separate condition, though, must meet the same test of 1,250 hours. So although somebody may qualify for one condition, subsequently, if they've fallen below the 1,250 hours, they may not qualify for an additional FMLA condition until their work hours meet that threshold. Now, another easy defense is when management does not post and keep updated a posted notice containing the information in Wage and Hour Division Publication 1420. In 2008, FMLA was expanded to include military family leave as well as military caregiver leave. Now let me get to the good part. The Postal Service has recently been sending out the WH-382 forms, which is their response to somebody's application for FMLA leave, with a check mark under more information needed in Section 1 and or incomplete and insufficient documentation in Section 2. But they have not been indicating what exactly it is that they need. See, most, if not all, medical providers are knowledgeable or have the resources to comply with the FMLA in providing the documentation with the necessary information required by law. Therefore, it is quite apparent that the Postal Service is looking for more information than is required by the FMLA. What are they seeking? Sometimes when pressed, they have slipped and admitted that they are seeking the medical facts related to the condition. What exactly are medical facts? Well, arbitrators have agreed for the employee's physician to reveal the medical facts would be akin to revealing the diagnosis. And according to USPS policy letter dated January 11th, 2006, or M-1629 in the MRS, a diagnosis is never required by the Postal Service for FMLA or for any other purpose. We know how that goes. Management resolves these issues at the national level, and then they try to circumvent them at our level, at the local level, without national finding out. So that's why it is up to us, and that is why I made this YouTube channel, NALC Steward Academy, to help you defend yours and others' rights as we share, educate, and build each other up and hold management accountable for these violations and schemes. Now, management is responsible for responding to the employee's request for FMLA within 5 business days with an eligibility determination. And then, if the certification is still not complete, informing the employee on what other information is needed. Once the employee has submitted the sufficient information, as we've said before, a diagnosis is not required, but they are using this ruse at the moment. But barring that, if everything is complete, the employer has another 5 business days to designate the leave as FMLA protected. Now, the Postal Service uses the standard form WH-382 for this. It's a uniform form, and they were having all kinds of problems with FMLA coordinators making extraneous comments that violated the law. But guess what? Leave it up to the Postal Service to find other ways to do this. Now, I had an arbitration recently that our National Vice President, Mr. James Henry, arbitrated for me before he was appointed as National Vice President. So thank you very much for that. In this decision by arbitrator Glenda August, dated August 25th, 2021, cigar number 35313, she even addressed National Pre-Arbitration Settlement M1558, which of course I put in the file, and applied it not only to Step B representatives having the authority to make the determination whether a certification submitted by an employee has the required information to obtain FMLA protection, but also expanded this authority to arbitrators. And then she exercised this authority by approving the grievance FMLA request in this case. She further debunked another common management misconception by defining what clarification means. See, sometimes we get certifications or WH-382s that say more clarification is needed. What does that mean? Well, by law, all it means is that the Postal Service has the right to contact the healthcare provider to understand the handwriting, because perhaps it's unclear, written by a doctor, or the meaning of a response. Well, nowadays, FMLA certification is rarely, if ever, handwritten. It's all typed. So this would never give management the right to seek more information than is required by law or by the certification form, as they are doing. In this case, the grievant had submitted a Kaiser form, as they have their own FMLA forms. The NLC also has some simplified FMLA forms, 6 of them in fact, which you can take to your healthcare provider. They are clear to the point and not intrusive in any way, and have field for all of the information required for FMLA protection. And I will include a link for these also in the comments section. Now, in this case, arbitrator Glenda August also clarified the one recourse the Postal Service does have, which is to request a second opinion at their expense, which they are loath to do. She also awarded the carrier administrative leave for any sick and/or annual leave he had utilized prior to the arbitration, which should have originally been designated as FMLA protected leave. And it came out something to the ballpark of $1,200. And this is why, brothers and sisters, management is trying to use subterfuge or deceit to obtain information they have no legal right to. If you don't know your rights in this regard, you will probably just give up the diagnosis. Yes, you will give in, but no more. Another deceitful tactic management employs is requesting medical documentation when you call in sick for 3 days or less for a condition you already have FMLA certification for. Do you have to provide additional medical documentation? No. Per National Memorandum dated November 24th, 2015, or M-1866 in the MRS, page 10, paragraph 3. It reads, when an employee uses leave due to a condition already supported by an FMLA certification, the employee is not required to provide another certification in order for the absence to be FMLA protected. FMLA law also does not allow the Postal Service to require recertification for qualifying exigency leave, military care leave, and also bars the second and third opinion options for the Postal Service regarding these types of FMLA leave. Now, on February 2nd, 2023, the Biden-Harris administration marked the upcoming 30th anniversary of the Family and Medical Leave Act by announcing new actions to support and advance women's economic security. President Biden issued a presidential memorandum to support federal employees' access to leave when they need to care for themselves or a loved one. The memorandum calls on heads of federal agencies to support access to leave without pay for federal employees, including during their first year of service, to ensure employees are able to bond with a new child, care for a family member with a serious health condition, address their own serious health condition, help manage family affairs when a family member is called to active duty, or grieve after the death of a family member. The Office of Personnel Management is further directed to provide recommendations regarding safe leave to support federal employees' access to paid leave and leave without pay for purposes related to seeking safety and recovering from domestic violence, dating violence, sexual assault, or stalking. Now, these may include obtaining medical treatment, seeking assistance from organizations that provide services to survivors, seeking relocation, and taking related legal action. The Department of Defense also issued a memorandum expanding the military parental leave program. Active duty service members are not eligible for 12 weeks of parental leave following the birth, adoption, or placement of a child for long-term foster care. The expanded leave erases the previous distinction between primary and secondary caregivers, enabling both parents to take time to care for their children while balancing the needs of their unit. And it is in addition to medical convalescent leave, which continues to be available for birth parents recovering from pregnancy. Additionally, service members may request to take the 12 weeks of parental leave in multiple increments of at least 1 week, which allows for flexibility to meet both family and mission needs. President Biden signed into law the Pregnant Workers Fairness Act as part of the bipartisan end-of-year omnibus law, which will provide basic, long overdue protections to ensure that millions of pregnant and postpartum workers have the right to reasonable accommodations in the workplace for pregnancy, childbirth, and related medical conditions. Under the new law, employers must make reasonable accommodations for pregnant workers and job applicants, which may include light duty, breaks, or a stool to sit on, without discriminating or retaliating against them. Now, the president also signed into law the Providing Urgent Maternal Protections, or PUMP, for Nursing Mothers Act, which extends break time and private space protections for nursing parents to nearly 9 million workers, including teachers, nurses, and farm workers. These protections will empower parents to continue expressing milk at work so they do not have to choose between their job or their infant's health. Now, a few years ago, I filed a grievance on this, and I got a really good Step B decision, which ensures that the employees at the Richmond Post Office have a clean and safe place to express milk for their infants. This same employee filed an EEO, and before an administrative law judge obtained expanded protections for this. So instead of letting these pencil-pushing bean counters that are working hard to interfere with your legal and contractual rights get you to give them up, hold them accountable. Yes, learn to defend your rights and others. As I mentioned, I will include links to all of the aforementioned documents for you to use in your grievance files and for further education. Please follow me on my YouTube channel, NALC Steward Academy. And until next time, brothers and sisters, don't let them get away with anything.